Occupational and Ordinary Morality, Role Differentiated Behavior, Professional Roles, and Ordinary Morality. In Chapter 2, we looked at the various definitions of professionals. Now, to some, it may seem that these two articles that read were merely philosophers quibbling over the meaning of words. Well, what do you define, or how do you define professional? What criteria do you choose, as opposed to what criteria does someone else choose? And it may seem that being able to define a profession seems somewhat unimportant. We seem to use the term professional all the time and have some sort of intuitive notion of what we mean by a professional. But it turns out that understanding what constitutes a profession is important because professions often have attached to them special privileges or responsibilities. What Chapter 3 attempts to do is look at least several of the articles attempt to look at and ask the question whether or not professionals do in fact have a different moral standard that they can follow. So for instance, in the first article, Professional Responsibility of the Criminal Defense Lawyer, the Three Hardest Questions, Monroe H. Friedman. In his article, Friedman looks at three questions that raise moral dilemmas for defense lawyers. What Friedman's attempting to do is show that lawyers do in fact have a different set of moral standards that they're supposed to follow, and that the types of things that lawyers do in the context of a courtroom or in their role as a lawyer justifies or allows for these types of activities. So the three questions Friedman wants to examine are these. First, is it proper to cross-examine a witness who you know is telling the truth in order to discredit his or her reliability or credibility? So you could imagine a situation in which, if I'm an attorney, I may go to my client and say, this is the witness list given to me by the prosecution. This person is going to be testifying, and they're claiming they saw you coming out of the store carrying the stolen television. And my client says to me, yep, in fact, that person did see me. I saw them, they saw me, and I ran. The question I now have is, if that witness is put on the witness stand, do I have an obligation to try to discredit their testimony? So my client has already told me that as a matter of fact, this witness is telling the truth. Now, as a lawyer, and as a defense attorney in particular, I'm supposed to question the state's evidence. In such a case, where my client doesn't want to plead guilty, even though I recommend that they do, what am I supposed to do when this truthful witness comes to the stand? This first question notes the tension between our everyday morality and what Friedman says constitutes a legal morality, or the morality of the defense attorney. For an everyday use, if I try to question the integrity of someone who I know is telling the truth, then I'm acting in a dishonest manner. I know this person's telling the truth, I'm attempting to make them look bad, and that seems, on the face of it, unethical. On the other hand, Friedman says that this is exactly what a defense attorney is supposed to do. We'll talk about that as we get to Friedman's answers to these questions. The second question that Friedman examines is it proper to put a witness on the stand who you know will commit perjury? Now, these types of questions, especially this, is the sort of thing you might see on an episode of Law and Order, that a defense attorney will have a client who they know will do anything to get off. And the question is that as an attorney, should I put this person on if I suspect that they're actually going to lie on the stand? So let's say I believe they're going to lie. I inform my client that I can't put you on the stand if I think you're going to lie. The client says to me, I'm not going to lie, I'm telling the truth. But still I know that this client is not telling the truth, or I at least have a deep suspicion that this client will lie once they get up on the stand. Can I stop them from getting up on the stand? Can I say, fine, I'll put you on the stand? Now, we should note that every defendant has the right to get up on the stand and plead their case. So as a defense attorney, I can counsel against such actions, but I can't actually stop someone from doing this. But should I encourage it or allow it, or what? That's the question Friedman's asking. What should the defense attorney do in such a situation? The third question he wants to look at is it proper to give information to a client when you believe such knowledge will tempt him to commit perjury? Now, Friedman later refers to this as the anatomy of a murder scenario or situation, which is also part of one of the video clips you have in this chapter to watch. Essentially, the question is this. When I go and meet with my client, if I'm a defense attorney, and I give my client the information they need to get off, then is that moral? So, for example, let's say before I hear any of the details of my client's case, I come in and say, look, here's the situation. This is taken directly from the Anatomy of a Murder case, which is based on a film, 1959 film. Imagine that I come in and say, here are the 3 ways you can get off for murder in this state. You can be crazy, you can have done it out of passion, you can have acted in self-defense. The question is, should I give that information to my client before hearing what they've said? In other words, giving them the out. This gives the client the opportunity to perhaps tailor their story to one of the defenses that would get them off. And this is one of the questions Friedman also wants to look at. Say, does the lawyer have an obligation to give information that will induce the client to lie on the stand? Duties of the defense attorney to the court. According to Friedman, the moral dilemmas faced by attorneys come from their dual role in our court system. A defense attorney has certain obligations to his or her client. They also have obligations to the court system. So we have in our country an adversarial system based on the idea that the most effective way of determining the truth is to present conflicting views to the judge and jury. What happens in the case of the defense attorney is that they are pulled in 2 directions. On the one hand, a defense attorney is responsible to show candor towards the court. Candor is a general truthfulness towards the court. On the other hand, sometimes that requirement of candor can work against the person they're attempting to defend. So the question is, what happens, or what ought the attorney to do, when there is a conflict between these 2 duties? This is where the moral dilemma comes into play, and oftentimes the criticism of lawyers. Because viewing lawyers as part of a system that's supposed to make sure the guilty are put into jail or convicted and the innocent go free, that's our ideal of the system. When you have someone within that system attempting to get the guilty off, so to speak, this often places lawyers in a bad light. And what Friedman wants to argue is that we shouldn't view lawyers who do this, who use the means they have available to them in defending their client, we shouldn't view those lawyers as doing something immoral, because their particular role within this adversarial system deems this sort of action appropriate. So lawyers aren't doing anything wrong, they're simply playing their part in a system, and what appears to be immoral activity is actually a conflict between their role or their obligations to the system and their obligations to their client. Duties to clients. As was already mentioned, the defense attorney has a duty both to the adversarial system of which they are part and to their clients. Their 3 main obligations are as follows. 1, a defense attorney is to preserve client confidence. That is, anything that a defendant says to their attorney is confidential information that the attorney cannot disclose. The only exception to the confidence is when the client states that they are about to do some illegal activity. So if they simply tell what they have already done, are honest about it and say, yes, I did commit a crime, for instance, then that sort of information can't be divulged. And anything about previous crimes can't be divulged by the defense attorney. But as long as they're not claiming or stating that they're going to do something illegal, attorneys have to preserve that sort of confidence. Defense attorneys also must lie on behalf of their client. In fact, they do this all the time in a court. Attorneys will stand up in the court of law and say, not guilty. What they're actually saying, it seems, is not legally guilty. So you can see here already the candor towards the court is drawn into question, because when the defense attorney stands up knowing their client's guilty, perhaps their client has admitted their guilt to them but believes the state doesn't have a strong enough case and so won't admit it in the court of law, the lawyer is actually saying to the court that this person is not legally guilty. But at the end of the day, after the arguments have given, the case they're trying to make is that this person is not guilty in fact. And so there's a fine line between stating not legal guilt, that the person is not legally guilty of the crime, and that they are not in fact guilty. Because even if you believe that the prosecution hasn't made the case, there's still the possibility, a very strong possibility, that the person is in fact guilty of the crime. The third duty of the defense attorney is to be a zealous advocate. That is, the defense attorney must, as strongly as possible, defend their client. So when an attorney, or if an attorney, were to show any sort of doubt about the innocence of their client, or doubt that the prosecution hasn't made a good case, so if they were to give an indication that they think the prosecution's case is in fact a strong one, and that they have proved their case against the client, that would show that the defense attorney wasn't being a zealous advocate. The defense attorney, simply by their actions, by the way in which they act in the court, the types of questions they ask defendants, could in fact reveal that they believe their client is guilty and thus would violate their obligation to be a zealous advocate. Conflict of duties. As mentioned on the previous slide, the three duties that a defense attorney has to their client is to preserve client confidence, to lie on behalf of the client, and to be a zealous advocate. It's just these three duties that often come in conflict with the duties that the defense attorney has to the court. So in maintaining a confidence may require that the attorney withhold evidence. Friedman-specific questions. Having set up the obligations the attorney has to the court system and their obligations to their client, Friedman then goes to answer the three questions he poses at the beginning of his article. The first deals with the limits of cross-examination. Should the attorney attempt to undermine or discredit the truthful witness? According to Friedman, that's exactly what the attorney ought to do. If the attorney does not attempt to discredit the testimony of a witness, the attorney has in fact implicitly said that what this person said is true. It's also the case that by not cross-examining the truthful witness, the attorney is betraying a confidence. The only reason an attorney would not cross-examine the truthful witness is if they already knew that what the witness said was true. Well, the only way they're going to know that is if their client told them that what this witness says is going to be the truth. And so in such case, that would undermine the confidence that the defendant would have in their attorney, would undermine generally all confidence clients have in their attorney if they knew that their attorneys would not cross-examine someone who had told the truth. And so undermining confidentiality and undermining the confidence that one has in their attorney is not good for a legal system that's built on this adversarial system, where there's one side representing your interests and the other side representing the interests of the state. The second question is the perjurer. Should the attorney allow the perjurer, or the suspected perjurer, of testifying? Well, it seems, according to Friedman, that there's no real alternative for the attorney in such a case. The attorney can't withdraw from the case without telling the judge why they want to withdraw. And they can't go to the judge and say, because my client is now going to lie to the court. That would again betray confidentiality, and it would undermine the confidence that the defendant has in the attorney. If, in fact, the judge were, for some reason, to allow the attorney to withdraw from the case, what would the result be? Well, a new attorney would come on the case, and the client, at that point, would have, one, less confidence in their attorney, maybe not tell them all the facts because they think that some of the things they say might be incriminating, and they're worried that the attorney will doubt their truthfulness and not put them on the stand. Or, if it is, in fact, a perjurer, the perjurer, when they get a new lawyer, is simply going to say, well, I better keep this to myself, what I intend to do. And so we don't actually stop the perjurer from testifying. We simply have them testifying while using a different lawyer for their defense. The third question is the informed perjurer. The question is, should the attorney give certain information to a client that could be used to cause them to perjure themselves? So when I meet with a client, if I'm a defense attorney, the question is, here's the crime let's say they've been accused of murder. I could ask the defendant, tell me your story, tell me what happened, I'll tell you what the law says. On the other way I could do it is simply say, you've been accused of this, here's what the law says, here's the way in which you can be justified in the actions that you've been said to take. Now tell me what happens. Well, in part, what Friedman says is we can't withhold this information. First of all, to require that the client tell their story first before we let them know the law is to prejudge them. In other words, we're already saying they're a perjurer. That's going to undermine the confidence that the defendant has in their attorney right off the bat. The second sort of problem with this is that each individual has a right to know what the law says. We can't have secret laws. Society can't have laws that you don't know about. So the fact that I, as a defendant, say don't know what the law says about a particular case or a particular crime I'm accused of doesn't mean I don't have a right to know that beforehand. So when I go in to meet with my client, I'm required, even if that information might be used by that client, I'm required to tell them what their rights are, to tell them what the law says. Code of Legal Ethics. Having made his case for doing those three things mentioned at the beginning of the article, namely cross-examining the truthful witness, putting the witness on the stand who you know will commit perjury, and giving information to a client that may tempt them to commit perjury, Friedman then asks, does the Code of Legal Ethics give us any guidance in such cases? Lawyers, after all, have a whole canon of ethics, and perhaps the answer to these sorts of dilemmas, these sorts of problems, are found there. What Friedman notes is, in fact, the Code of Legal Ethics doesn't help us in these situations. And he cites two canons. There's Canon 37, the exception to confidentiality. So the question is, when can a lawyer breach confidentiality? So in some of these cases, obviously, would require breaching confidentiality. Can he do it? Well, a lawyer accused by a client may disclose privileged information. So if a lawyer is being charged with some sort of incompetence, then it would be fine to disclose privileged information, because at issue here is the lawyer's job given certain circumstances, given the facts of a case, that they didn't do their job properly, and so that information, of course, can be disclosed. The announced intention by the client to commit a crime justifies disclosure of privileged information. Well, I mentioned this before, and it seems clear that here, if the client says that they'll make up a story, that would, in fact, justifying breaking confidentiality. But we don't stop there, because in Canon 29 also has something that calls into question my ability or my right to go ahead and tell that my client is going to commit perjury. 29 requires a counselor to inform prosecutor of perjury by opposing witnesses. Does not require informing prosecutors of the perjured testimony of defense witnesses. So the defendant, or defense witnesses generally, if they commit perjury, places no obligation on the defense attorney to say anything. So even though Canon 37, even though perjury is a crime, Canon 37 says, well, if your client announces their intention to commit a crime, then you ought to go ahead and disclose that information. On the other hand, Canon 29 seems to indicate that you are under no obligation to inform prosecutors about perjured testimony. So there seems to be a clear contradiction or tension here in the Code of Ethics. And especially this becomes even more difficult if the client actually hasn't announced an intention, but you simply suspect it. So in that account, there's Canon 37 doesn't apply because there hasn't been an announced intention. It just might be something you gather from the things that they've said. You put two and two together and it seems that they're going to perjure themselves. On the other hand, Canon 29 says, in fact, you're under no obligation to inform in these cases. And so what Friedman notes is that, in fact, the Code of Legal Ethics doesn't have any way of resolving this problem. But at the end of the day, Friedman says these are things that defense attorneys ought to do, mainly because they uphold confidentiality, they maintain the confidence between attorney and the client, and they're part of a broader legal system, an adversarial system in which the best case needs to be made on both sides, for and against guilt or innocence. And that's the way our system works.